All right, I'm ready on Brown. This is case number 234489901. The people of the state of Michigan versus Nicole Brown. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
Good morning, Your Honor. For the record, Janice Stevenson appearing on behalf of Ms. Nicole Brown. Ms. Brown, ma'am, please tell the judge your full name.
Good morning, Your Honor. Nicole Brown.
Thank you. Today is the date set for pretrial conference. How are we proceeding?
On behalf of Ms. Brown, Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter?
Judge, it's the first scheduling of the pretrial conference. I respectfully ask the court to adjourn the pretrial conference to give the complaining witness one more opportunity to appear. I would note that I don't see the complaining witness in the waiting room at this time.
All right, the court is going to deny defense counsel's motion for dismissal, grant the people's request for an adjournment, giving them an opportunity to notify the complaining witness of the obligation that they appear before the court. I'm going to set the pretrial conference for October the 10th.
Can I please get a date sooner than that?
At 8:36 a.m. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Ms. Stevenson Esteban.
Thank you, Your Honor. Right now, I believe the current bond orders a GPS tether and personal bond. And I'm not sure if the court recalls that we have had some tether violations, but that Ms. Brown was, I think, last before this court on August 22nd. She was reminded of today's pretrial conference date. I am going to ask the court for release on personal bond, Your Honor, so that I think Ms. Brown does understand with all these tether violations that she's got to abide by a court bond conditions. I don't know. She was last at Naomi's Nest, I believe. And I don't think there was anything indicating that she could not return to Naomi's Nest. She's also previously requested that she be able to tether to Positive Images if they would have her. So I am asking the court for personal bonds, Your Honor.
So what happened with the last time we were here? Because I remember she told me that she lied and said she had an addiction because she just wanted to get out of jail, and that she didn't have anything wrong with it. So why is she trying to go back to Naomi's Nest?
I think that I'm not sure why Ms.
Right,
Ms. Brown would have made that statement to the court. But again, I don't know that there's anything from Naomi's Nest indicating that she can't go there.
Ma'am, stop talking. Because you play games. You play games, and listen, you're gonna lose every time. You're gonna lose. You're gonna lose every single time. You're gonna lose. Okay. Ms. Ritter, any response to the motion for the personal bond? I'm assuming you mean without a GPS tether.
My request would be without GPS tether, Your Honor.
Ms. Ritter.
Your Honor, at this time, the people are going to ask the court to deny defense counsel's motion and keep the GPS tether. In this case, Judge, I don't know if the court remembers, but there were actually 2 tether violation hearings that were held in front of Your Honor. And in both times, Ms. Brown violated the conditions of the tether by going into the exclusionary zone. And Judge, I just want to bring to the court's attention that this incident happened at a residence where Ms. Brown and the complainant witness both resided together. The investigator's report is not clear what the relationship is, but the complainant witness and Ms. Brown at the time of the incident were both living in the same household. So for those reasons, Judge, again, I'm just going to ask the court to deny defense counsel.
So they lived in the same household? What you mean? Like,
the complainant witness and Ms. Brown resided together at the time of the incident.
okay. Ms. Stevenson, you agree with that?
I'm just looking over the
So is
I don't know that
is the exclusionary zone that house?
Correct.
Where are you seeing that in the report? Ms. Stevenson is saying she doesn't know that she see that.
So in the incident report, Judge, the address listed for the complainant witness, Ms. I, is the same address as the address that Ms. Brown has listed in the report.
Okay.
The raid marker address.
okay, I see that. I don't see that in the body.
Okay.
I do see that.
All right. Then the court is going to change the court date. I'm going to transfer the case to Judge Austin Garrett, who has a lighter schedule than me, because Ms. Brown think we could just give her court date like we don't. Okay. So nonetheless, so since Judge Garrett has a lighter docket than mine, his court date is earlier than mine. So she's going to get a couple of weeks earlier, but I'm still leaving her on a tether. So can you please stop interrupting? I mean, I don't understand, ma'am. What is it, Ms. Brown?
I was just wondering, because I talked to my old boss, I was wondering if I could just tether back to home and I so I can start back working.
Okay, so again, you interrupted for no reason. The court is going to transfer the case to Judge Austin Garrett. And his pretrial date is September the 20th. And I'm gonna still put it on his docket at 8:36. I know they're not gonna know what that means, but we do. And then the complaining witness is required to appear. And I am going to I'm going to deny defense counsel's motion for a reduction in the bond and a removal of the tether. I'm going to keep the tether condition, and Ms. Brown can tether to Naomi's Nest, or where did you say positive images?
Yes, Your Honor.
She can tether to Naomi's Nest. Or positive images. Anything further?
Not from the people, Judge. Thank you.
So is it personal bond, Your Honor?
Yes, it's a personal bond.
Okay.
What is her bond now? You're saying it was a dollar amount?
No, it was personal prior to the tether violation of August 22nd, and then the court did revoke the bond until today.
Oh, okay, so I'll reinstate that personal bond. How much was the personal bond?
$10,000 personal bond set on July 7th by the magistrate.
It won't be 10,000. It would be it will be just my normal or customary $3,000 personal bond plus the GPS tether, tethered to Naomi's Nest or positive images. Anything further?
No, thank you, Judge.
Your Honor, nothing more for the record. Could we go back to brief breakout with Ms. Brown. I know the jail probably has to move on, but I just briefly for her.
Oh, there he is. He just came back to the table. I could tell.
Okay.
All right, now let's see. 'Cause let me share my screen.
There.
Yes.
He connected and he's muted now. Can you hear us,
Okay.
Mr. Kowalski?
Yes, he can. Mr. Kowalski, didn't you just come back to the table? You just came back to your device. Unmute.
No, I've been at my device. I
Well, why
promise.
did it take you so long to connect and turn on your video camera?
I
Why have we been sitting here waiting on you to connect and turn on your video camera if you've been sitting at your device?
I have no idea, but I swear to God, I've been at my device. I've been sitting here since 8:55. I haven't left this seat that I'm sitting in right now since 8:55. And this is my cell phone that I'm using as a camera. I have not. I promise you, I've not. This seat I've not left here at all. I promise. I swear. I don't know what just happened, but I don't know.
Okay. This is case number 235-641-901, the People versus Stephen Kowalski. Defendant is charged with 1 count of controlled substance, illegal use of marijuana. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing by Zoom with Mr. Stephen Kowalski, who also appears by Zoom. Mr. Kowalski, can you please state your name for the record?
Steve Kowalski.
Thanks.
Is it Stephen?
Or Steven, yeah. I just go by Steve.
And is your middle name Nicholas?
Yes, ma'am.
Thank you. And Miss Cleveland, you don't have to put yours on yet. So today is the day set for sentencing. I have had an opportunity to review the pre-sentence report. With respect to the report, are there any additions, deletions, or corrections on behalf of the people?
Judge, the people had an opportunity to view the pre-sentence report. I just want to verify if the plea agreement was correct, because I see that the original charge was possession of narcotic or cocaine less than 25 grams. However, the final charge is use of marijuana.
Yeah, I see that. I don't know.
It is correct. I've got a copy of the plea form. If that's helpful, I can send that to anybody that would like to see it.
Mr. Flanagan, put your email in the chat and Mr. Cohen can send it to you, and then you can forward it to Ms. Ritter.
Yes, ma'am.
Judge, that was the only inquiry the people had as far as additions, deletions, or corrections.
All right. Any additions, deletions, corrections on behalf of the defense?
I didn't see anything.
All right. With respect to sentencing, anything on behalf of the people?
Judge, so looking at the plea agreement, it looks like the plea agreement was a charge reduction with a sentence agreement of 6-month probation, terms and conditions set by the court. Understanding the police description of the offense, Your Honor, and the recommendation from probation for drug treatment program, the people do understand that it is at least, I think, 14 months to enroll into the drug treatment program. So if the court does deviate from the plea agreement, the people have no objection from that.
On behalf of the defense?
Well, Your Honor, this was a negotiated settlement at the district court level that was done on the day of the preliminary examination, I believe taking into account the nature and circumstances of the case itself in terms of Mr. Kowalski's perceived culpability, as well as the potential for some Fourth Amendment issues. So this was a contemplated minimal or de minimis probation for a relatively minor charge under the circumstances. Mr. Kowalski has been making efforts to get enrolled in substance abuse treatment on his own. He's been working with my social worker, Randy DeShone. He is, I think, struggling with the lack of substance abuse treatment with his insurance. So he does have some insurance, but it doesn't cover a whole lot. And so he's, I think, been able to get into one detox program and is in the process of trying to get enrolled into some other residential treatment programs. I've referred him, or at least suggested that he investigate Shar Macomb as well as Dawn Farms. I've heard good things from my office and coworkers about those programs. So what I would ask this court to do is follow the sentencing agreement, give Mr. Kowalski the opportunity to work with the probation department to maintain his sobriety, as well as continue his own individual efforts to get enrolled in appropriate substance abuse treatment. And if there is a violation that is based upon controlled substances or any other issue, I mean, the court, I think, has the authority to extend probation and modify the terms and conditions as appropriate based on Mr. Kowalski's performance on probation. So I would ask that we give him the benefit of the doubt, allow him to try and get into a program, test with probation, and go from there.
All right, so the court had an opportunity, as I indicated, to review the pre-sentence report. And whoever negotiated this plea, I just want to say that it was shame on them. Shame on them. That's ridiculous. So first of all, a 6-month probationary period on a drug case is ridiculous on every level. On every level, a 6-month negotiated period for a drug case is ridiculous. So that you might as well fine the person and let them go, right? So here's what I'm going to do. Here's what I'm saying, and I'll give you an opportunity to discuss it with your client. Number one, on page, well, first of all, he has 2 previous drug convictions. 2 previous drug convictions. Okay. And then on page, oh, my printer printed kind of funny. So let me see. It didn't print my page number. Page 2. I think it's page 6. Yes, okay. On page 6, it says, on page 6, the substance abuse use and treatment section says that he has self-reported that he last used crack cocaine May the 16th of 2023, that he last used Xanax and Klonopin May 16, 2023, all on the same day. He showed up for his drug test and for whatever reason said he couldn't submit to the drug test on May 17th. And then he was told to return on May 18th for a drug test, and he failed to appear. I will not accept the plea offer, the plea agreement. I will not accept it. I will not accept the sentence agreement. And if he does not want to do the longer probation with drug court, I will give him an opportunity to withdraw his plea. You all can return back to the felony docket. I won't accept that. That's a ridiculous plea, a settlement offer. And I'm not going to agree to give anybody who just used crack in May a 6-month probation. So you can talk to your client. If he doesn't want to do the longer probation and a referral to drug court, then he can withdraw his plea and you all could go back to felony.
Can I request a breakout room, please?
Absolutely.
Thank you.
Yes.
All right, I'm ready on Kowalski. All right, we're back on the record with case number 235641901. Mr. Cohen.
Thank you, Your Honor. After further discussion with Mr. Kowalski, he is wishing that this court proceed with sentencing today with the understanding that he'd be put on initially an 18-month period of probation and be referred to the drug treatment or sobriety court, and he is willing to participate in that.
I'm great. That's great. I'm so thankful. That's what I want to hear. So what I'm going to do is, so I'm actually going to send Miss Cleveland's preliminary observation is that Mr. Kowalski is eligible. I'm going to proceed under that thought process, and then if for some reason he is not, after she speaks further with him, then we will, I'll set it for sentencing back. But I'm looking at his pre-sentence report and I don't see anything in it that would disqualify him from participating in the drug court program. I am therefore going to sentence him to sobriety court. And I'm actually not going to do the 18 months. I'm going to do the 14 months, the lowest number of months that Judge Holmes will accept. Mr. Flanagan, I do need a 14-month date. That looks like it would be, let's see, August, that's 12, 34. Okay, so October the 29th of 2024 would be the 14-month date. Of course, Judge Holmes at her liberty and based on her schedule will may change that date. And then I am going to send him to the sobriety court. And that's the only condition I'm going to set, and I will leave the remaining conditions up to Judge Holmes. So what I will do, Ms. Cleveland, can you give me the date for Judge Holmes' docket that we would be placing Mr. Kowalski on?
Your Honor, I'm looking at the schedule. Today is the 29th. I believe the 12th, September 12th would be the most readily available schedule for our judge.
All right, and then I will say, actually, I need him to submit to your analysis until that date. I need him to submit to your analysis once a week.
Yes, Your Honor.
Because they don't have a drug screen for him. They don't have anything for him.
And Your Honor, I would also ask, because I have to see him in person to do further assessments for our program and the begin the intake process. So may the counsel and the client be aware that September 7th would be the best day for me to see him in person at 36th District Court.
All right, and you can give them more information about that in the breakout room. Mr. Cohen, will you be going in the breakout room or no? You don't have to.
I need to run to Judge Gillis for a matter at Third Circuit Court, Your Honor.
Okay, all right. And you were appointed, correct, Mr. Cohen?
I was appointed, yes, through Neighborhood Defender Service.
All right, so once he's officially in sobriety court, the staff of lawyers will, for sobriety court, they will take over his representation. Mr. Kowalski, I am going to send you to the breakout room with Ms. Cleveland, and I